and then you said that you are entitled to a jury trial and the issuance of a child support order, and no, you're not. You're not.
So you guys are allowed to go against Supreme Court law, is that it? Because it's under a you can't have something without due process in a jury trial. Really? Because I just beat a case and had 2 cases nollied and dismissed under judicial clause. Like, what jurisdiction?
One thing real quick.
Yeah.
So we did file an objection as well. I called and I got a court date of August 19th of 2024 at 9 a.m. We mailed it in on the 26th, and I served a copy to Mr. Schwartz. In the meantime, he must have gone to the clerk's office, filed an objection, and he got this date. So it's my understanding we have 2 different dates for objections, but both plaintiff and the defendant have filed an objection.
Yeah, I know that. I was just going through his.
Oh, okay. All right. Just wanted to make sure that we have the different dates.
You have an objection that she wants to be able to enroll the children in extracurriculars during the school year. That's your objection,
yes,
right?
Yes. Yep. Just clarification.
Yep. I just hadn't gotten there yet.
All right. Thank you. Sorry.
That's okay. Let's see. So, Mr. Schwartz, I was looking back at the judgment. Let's see here. Oh, this is a second file. So, Mr. Schwartz, are you saying that there's a clause in your judgment of divorce that the parties be required to leave 50% of their estate to the children?
Yes, there is a clause in our divorce that states that. And at the time I was, I didn't have any future plans of meeting anybody else or moving forward. And now that has happened, because I am still young, I do have a daughter, biological daughter that I have to include in that stuff, and it just doesn't work, Okay,
so Mr. Schwartz, I can't go back and change a judgment of divorce.
Okay.
I mean, once the judgment of divorce is entered, it's entered, and that's it.
Okay, so then I'll just leave everything in my future wife's name, and I'll put it in a living trust to where nobody can touch it. That's fine. Because no court can go.
So, and then you said that you are entitled to a jury trial and the issuance of a child support order, and no, you're not. You're not.
So you guys are allowed to go against Supreme Court law, is that it? Because it's under a you can't have something without due process in a jury trial.
So no, none of that's true.
Really? Because I just beat a case and had 2 cases nollied and dismissed under judicial clause. Okay. What jurisdiction?
So child support is entered, you had due process, you had hearings, it was entered, you provided your financial information. If you're indigent and not working, you can't afford your child support, the resolution of that is to get a job. So
I am working, but the thing is you as a court do nothing for me. You as a court have failed me miserably. You as a court also told me that the Michigan Child Custody Act is a private act. It's not, because if it was a private act, it wouldn't be on your website through Lenawee County as a handbook. It wouldn't be across the state and every other county as a handbook. You as Lenawee County fail people miserably and don't protect others.
None of that really applies. So thank you. And
then let's push it to a Supreme Court matter, Your Honor, because
you can do that. You do have the right to appeal this to the Court of Appeals, and you have every right to do that. But
I want this whole case dismissed under judicial bias because you used to be my court-appointed attorney back when I was 17. And I don't feel I have a fair trial through this court. And
Mr. Schwartz, I represented more than 10 people a week for a period of 10 years. I may have represented you. I don't remember you. It wasn't on this case. And so there's a 5-year period that has passed. So, Mr. Schwartz, I'm not going to recuse myself because I represented you so many years ago on a completely different case. So no.
I feel that I'm not getting a fair trial because of it, so I'll turn it into the JTC.
This isn't a trial. This is an objection hearing. And I would grant your request if it was something I was able to grant you relief on, but these are things I can't grant you relief on.
because I've been seeking help because I can't afford it. So yes, I do go to other lawyers and seek help. And
Excellent.
also,
So when you can hire that attorney to do an appeal if you'd like. But so just to make a thorough record, I can't go back and change a judgment of divorce based on the reasons you said. I cannot give you a jury trial on child support. And yes, the referee does have, no, and the referee does have the right to issue a uniform child support order. If you wish to appeal that, feel free. So, Ms. Stone, what you're saying is your objection will be heard on the 19th of August?
We were hoping that we would be able to address all matters today because it does deal with sports that start just prior to school.
I object to that. Absolutely not. I had to wait for your guys' stuff that you ejected. It is not for that matter.
So, Ms. Stone, all right, Mr. Shorts, Ms. Stone, we'll hear it on the 19th, all right?
Thank you, Your Honor.
All right. Thank you, Mr. Shorts and Ms. Shorts, Ms. Stone.
Okay, wait a minute. Why am I being dismissed? You haven't even gone through my whole entire case, so you're just going to go ahead and dismiss it and not even go through the whole process.
Those are your objections. That's all I received.
Really? Because on the back of that, there's a quorum non-judice, and you haven't even spoke about that.
A what?
Quorum non-judice. It's in the packet.
A what?
Quorum non-judice. It's in the packet that you have, Your Honor, and you haven't even spoke on it.
Because it doesn't apply.
Riley, thank you for, that was going to be my suggestion, to log out and log back in, but you did use the chat.
I am here on that matter, my honor. I am, for the record, on the record, and let the record show I am not a 13th Amendment free Negro slave, nor chattel, nor 14th Amendment United States corporate citizen. I am a national, I am a Moorish American, and I have